What is pre-import condition?
Interestingly, pre-import condition is not defined in any of the notifications, and it is not defined even in the foreign trade policy. When we argued before Gujarat High Court, that was one of the arguments that whether doctrine of void for vagueness must come into play for non-defining such a condition. Having said that, I think the revenue wants to take this literal interpretation is that by pre-import it is meant that first you import the goods, and once you import these goods, the lot which is imported is actually used in manufacture of exported goods, and then these goods are finally exported. So predominantly and essentially it means that the goods are imported first, and that's goods which are imported is used in manufacturing for exported goods to meet the pre-import condition, which could ideally be not possible or could be very difficult in lot of circumstances if it comes to literally following the meaning of pre-import.
What is pre-import condition controversy?
I think before we go to the pre-import condition controversy, it is important for us to take few steps back when this transition into GST happened. And when this transition into GST happened, the advance authorization benefits were curtailed with respect to exemption to IGST tax. And that's when lot of petitioners went to the court, and we argued the matter before Delhi High Court, which gave a favorable decision that the advance ruling scheme has an advance authorization scheme has an objective to provide working capital benefit, and that objective gets defeated, and hence the moot point before the court was that whether such curtailment affects the Indian exporters. And Delhi High Court gave the interim order, and then there was the revenue which went into appeal after the conclusion of the Delhi High Court order, which was turned down. Thereafter, the government realized that these benefits with respect to advance authorization scheme and the exemptions thereunder must come not only for the basic customs duty but also for IGST benefit. Now, what happened thereafter when this benefit was extended? The condition, which is this pre-import condition, was included for the Indian exporters to avail the benefit of exemption, and that's when the controversy with respect to pre-import condition got the inception.
How it impacts the Indian exporters?
So see, how it impacts is that if we see the objectives of the Advance Authorization Scheme, the objective of the Advance Authorization Scheme is to provide working capital benefit. Now, if this pre-import condition comes into play, that benefit with respect to the objectives of the scheme gets defeated. So there is substantially no working capital benefit which would otherwise come to the Indian exporters. So the objective of the scheme gets defeated, and hence the moot point which now comes is that if the objective of the scheme gets defeated, then there can be two classes of exporters. One class of exporter which is first exporting the goods and thereafter claiming the benefit, and second class of exporters who's following this pre-import condition, first importing the goods and is then exporting. So will there be a lack of intelligible differential treatment to these two classes of exporters, especially denying benefit to that class of exporter who has already exported the goods and is claiming the benefit after the export has happened?
What is the way forward?
So I think as far as the way forward is concerned, of course, I do not want to comment on the outcome of the court and so on and so forth. But I think one fundamental aspect which remains important is that the government has realized the problem, the government has addressed the problem, and the GST Council along with the Government of India has, with effect from January of 2019, has removed this problem by deleting this condition. So I think the problem is only for the intervening period, and that again raises the fundamental aspect whether when this benefit was given in the public interest and when the assignment of that condition happens in public interest, why that intervening period must be subjected to this harsh condition. That will remain the subject matter of discussion and debate. But yes, I think the way forward will be that we will have to wait for the court order. We will have to specifically see whether what is the outcome of the court order, what happens with respect to that intervening period, what happens with respect to interest, what happens with respect to penalties, and so on and so forth, and whether the court will held this to be ultra vires the Advance Authorization Scheme under the foreign trade policy, which was the order of the Gujarat High Court, which we argued before Gujarat High Court, or will the Supreme Court dilute that version of Gujarat High Court or completely quash that order of Gujarat High Court? That only time could tell. But yes, as far as the exporters are concerned and as far as the way forward is concerned, I think they must do their arithmetic calculation. They must see that against which authorization licenses they have exported first and against which authorization licenses they have imported first, so that numerical data is ready, and if it comes to the demand being crystallized, they are aware of the details of those advance authorization, and it will completely depend on facts of different exporters, the details with respect to inputs and so on and so forth, to reach the final conclusion.